Welcome to Guns, Guns, Gear, and Guns with Gary Gunderson. I am Gary Gunderson. Franklin Armory released the Antithesis, a short-barreled firearm that is not covered by the NFA, but it was quickly pulled off the market a day or two later because the ATF said, hold up. In the meantime, Franklin Armory has purged the Antithesis from their website and YouTube page, even though one version of the firearm is still perfectly legal and approved for sale. So what's going on? First, let me define the major aspects surrounding this product. In simple terms, short-barreled rifles and short-barreled shotguns are regulated by the National Firearms Act, requiring fingerprinting, registration, restrictions, and other hurdles for ownership. The law specifically defines each of these items, so anything that falls outside these definitions is not regulated by the NFA. The Antithesis was designed from the beginning to have a barrel short enough that would be considered an SBR if it were a rifle. However, it is neither a shotgun nor a rifle, existing in a place outside either definition. How is that possible? A rifle is intended to fire from the shoulder a single projectile through a rifled bore for each single pull of the trigger. A shotgun is intended to fire from the shoulder a fixed shotgun shell through a smooth bore, either a number of projectiles or single projectile for each pull of the trigger. The Antithesis has a rifled barrel intended to fire from the shoulder, both single projectiles and a number of projectiles. The best equivalent that most people will know is the Taurus Judge, which is able to fire both 410 shotgun shells and 45 Colt cartridges. There was going to be an Antithesis model in 45 long Colt and 410 shotgun shells, as well as one in 5.56 and Antithesis multiple projectile assemblies. So what happened? Why the release and sudden pullback? Essentially, the ATF said it never approved the 5.56/multiple assemblies model. This has been through the court systems for a while, and earlier this year, the court ruled in favor of Franklin Armory that the Antithesis was a firearm by the plain text of the law and was not subject to regulation under the NFA. In late August, the ATF issued an open letter on these firearms, overruling a prior determination which was against the Antithesis. The key part of the letter is where it mentions that the Antithesis, specifically listed as a 14.5-inch rifle barrel to fire 410 bore shotgun shells and slugs in addition to 45 Colt cartridges, was found to be a short-barreled rifle previously, but that determination has been vacated, and the current status of the Antithesis is not a rifle, short-barreled rifle, or NFA firearm. In response, Franklin Armory has issued a voluntary recall and said if they cannot work this out with the government, it will resume litigation. The ATF issued a new letter clarifying what happened. They said in the settlement with Franklin Armory, they only agreed that the 410/45 multi-chambering would be classified as a firearm. They stated a version in 5.56 was submitted to them for review less than a month ago, along with an exotic prototype of 5.56 Sabo ammunition housing multiple smaller projectiles. The letter states they had not finished making their determination on the classification before Franklin Armory began advertising this new 5.56 model for sale, asserting that since it could also shoot a multi-projectile load, it was not a rifle. The ATF contends that all they did was submit an SBR'd AR in 5.56, and they created new exotic ammo, which would work in any standard AR, which is important. Essentially, the ATF is saying you didn't design this to shoot both, you just designed new ammo to fit in a standard AR. Franklin Armory is saying that since this is a firearm that shoots both single and multi-projectiles, it fits the definition of a firearm. The ATF's point is that if all you had to do was design new ammo, essentially there would no longer be any rifles, because that would mean anytime someone made a new rat shot cartridge or something, anything in that chambering would be a firearm instead of a rifle. That would theoretically also have to apply to every 5.56 rifle out there, which would also prohibit anyone from under 21 purchasing one, since federally rifles are for sale at 18, but firearms aren't until 21, which is an interesting aside I was not aware of. Importantly, this was part of the argument in the court case the ATF lost. However, and this is with me fully thinking the NFA is garbage, part of the judge's point ruling in favor of the 410-45 antithesis is that it was designed to fire both single and multi-projectiles. The 5.56 antithesis is the same chambering as every AR, according to the ATF, which is what the ATF is going to lean on in their argument and presumed further litigation. So the ATF is technically correct in that the new model was not designed for anything but 5.56. And yes, the ATF is right in that if this is allowed, then the SBR is essentially over. Don't even need to worry about that upcoming $0 tax. It would also open an easy path for other calibers to do this as well. We've already seen AKs fitted with this sort of multi-assembly ammo for fighting drones in the Ukraine, so if you manufacture with that intent in mind, how could it also not simply be classified as a firearm? I mean, then wouldn't it be a firearm since that ammunition does exist? Fine by me, but I think Franklin Armory is in for a battle on this one. The easiest workaround would be to create a new cartridge that is slightly different dimensionally from 5.56 and requires a different specialized chambering to fire both without affecting accuracy too much, mind you. And then it's not a standard AR and could be classified as designed for this purpose specifically. I'm also curious because I think they had talked about licensing out their antithesis to let other companies release these as firearms, but they're just ARs. I'm sure that other companies could then just say, oh yes, this is also manufactured for multi-caliber and single projectiles, but everyone else could just say it also shoots the other Sable cartridge without doing anything else. In litigation earlier this year, the judge ruled the antithesis was a square peg the ATF was shoving into the wrong hole.
And up next, a cylinder.
The circle.
I think that goes in
The circle.
the square hole.
But with this 5.56 model, the main ATF counter arguments would be that it's not designed any differently and that this is just an attempt at circumvention. You're essentially not allowed to construct something specifically to avoid the law. But that will depend on the judge and how they weigh that against the plain text. So what do you think is next? Litigation? Assuredly. Who do you think will win in the court case? Let me know in the comments below. If you've made it to the end of the video, please consider liking it, subscribing to the channel if you aren't already, sharing the video. All of it helps the channel grow. I also have a Patreon, which you can get to via the link on the screen. That's all for today. Thanks for watching.